Hello friends, this is IP Ashwini Rastogi. So what is voluntary liquidation? Whether it is beneficial for you to go for liquidation, so just we discuss what are the provision under the Insolvency Bankruptcy Code 2016, provision for voluntary liquidation, and what is regulation. We also discuss a case law so that we can easily understand the process for voluntary liquidation. So strike off is applicable where there is a no asset, no liability. A dormant company can go with the ROC for strike off. If you are a solvent company, then voluntary liquidation is a process. To realize your asset, appoint liquidator who will realize, distribute, pay to the shareholder. That is called voluntary liquidation. So if you are not a solvent company, you have a debt but you are not able to pay, then CIRP, Corporate Insolvency Resolution process for you. So this process we are here, it discuss voluntary liquidation. So how we deal with voluntary liquidation? So as I said, CIRP is applicable in case where you are a debt owned but you not able to pay your debt, then CIRP process is there. If you are a solvent company, then by passing a special resolution by the shareholder, or it is a creditor also there, 2/3 in value creditor given a consent to go for voluntary liquidation, then you will appoint liquidator, and liquidator will sell the asset, realize the money and pay to the stakeholder of the company. So this process it dealt from the Nclt also. So next, so our main practice in this area, we are expertise in the IBC. So we have advocates who dealing with the IBC cases. Secondary thing is valuation. In the voluntary liquidation, we also deal for valuation of asset, maybe some land and building, plant and machinery, or some stake in other company. So SFA valuation we also deal from other RB entity. We also in international taxation practice. So this is a snapshot for our main area of practice. So what we can do for you? Initial assessment, first of all we will see whether which option is viable for you, whether it is applicable, it is correct case for choose voluntary liquidation. So on the basis of initial documentation, we will give a recommendation, management recommendation, and after that to act on the given criteria. So this is for voluntary liquidation. So let us understand what is voluntary liquidation in a practical scenario inside into the IBC code with rules and regulation. So first understand in layman language what is the process for voluntary liquidation and how we will go for voluntary liquidation. So what are the law behind this voluntary liquidation? Section 59 of IBC is talk about the voluntary liquidation. Before IBC, there is a provision in the Company Act 2013 also. So after coming IBC, 1st April 2017 onwards, section 59 is viable for us. And also IBBI is given a regulation for voluntary liquidation. In the previous Company Act 1956 regime, there is also provision for voluntary liquidation. So practical aspects we will discuss from the Company Act point of view, from the income tax point of view, whether you required NOC from the income tax department or you can go without NOC from the income tax department. Might be there is some litigation pending before the income tax department, how that will be dealt with. We will also discuss whether excess paid to the shareholder will be treated as deemed dividend we will also discuss. So we will discuss in term of company hand also, whether it is capital gain or distribution asset by the company also. So all we will discuss in snapshot, very summary, in easily language, so you can understand what is the criteria for voluntary liquidation. So this is just our next, please. So voluntary liquidation. Next, a corporate person who intend to liquidate itself voluntarily and has either not committed any default. As I said, you are a solvent person, has no debt, or in case having debt, it will be able to pay its debt in full. ध्यान रखना, यहाँ पर फुल पेमेंट ही डेट की करनी है, आपको कोई हेयर कट नहीं मिलेगा. The proceed of asset to be sold in liquidation may initiate voluntary liquidation. So this is the whole scenario for filing of forms with the Nclt, and some public announcement is there for submission of claim by the financial creditor, operational creditor, by employees, authorized representative of employees or workmen. So after the scrutiny of claims, liquidator give a list of stakeholder. They will submit a compliance certificate. Preliminary report they have also to be submitted with the Nclt. And if anything is unclaimed dividend, they will deposit in the corporate voluntary account. So this is the scenario. So story behind the voluntary liquidation is that you can go for voluntary liquidation. There is no process defined for withdrawal of application. However, if your mala-fide intention is there, the liquidator can approach with the Nclt, kindly suspend this voluntary liquidation, since you are either not able to pay your debt, or you are some intention to defraud the creditor. So anything is fine. After appointment of liquidator, he can file application with the Nclt to suspend the process of liquidator. So here I mentioned form. Form A is generally we need to pass a SR, special resolution. That special resolution filed to the ROC in form number MGT 14, and GNL2 also is there. Once the liquidator is appointed, within 5 days of liquidator appointment, they will give a public announcement. Right after that, they will ask in the public announcement. They will ask, given a 30-day time period, kindly submit your claims. Operational creditor give their claim to the hard copy or through any mode. However, financial creditor within 30 days of liquidator commencement date, online, banker will file their claim online only. So compliance certificate there, preliminary report is there, final report is there. So anything left, they can deposit unclaimed money in the particular IBBI account. So all process need to open a bank account. The company will open a bank account. So however, company can file form J if after the filing voluntary liquidation, they will find I am withdrawing the voluntary liquidation application. Next please. So this is a viable section of 59 of IBC. A corporate person who intend to liquidate itself voluntarily, has not committed any default, may initiate voluntary liquidation proceeding under the provision of this chapter. This section is for Insolvency Bankruptcy Code 2016. The voluntary liquidation of a corporate person in subsection 1 shall meet the condition and procedure requirement as may be specified by board. It's IBBI. So without prejudice to subsection 2, voluntary liquidation proceeding of a corporate person registered shall meet the following criteria. Section 59 subsection 3A onwards, there is some criteria is there. A declaration of majority of the director of a company verified by an affidavit stating that they have to file an affidavit. They have made full inquiry into the affair of the company. They have formed an opinion either company has no debt or that debt will avail to pay itself in full proceed of the asset to be sold in the voluntary liquidation. So the company is not being liquidated to defraud any person. So declaration under clause A shall accomplies with the following document: audited financial statement for last 2 years and report of valuation report from the registered valuer. As I said, there is some asset in the company. We have to ask from the registered valuer, kindly give your valuation report, and on the basis of audited financial statement we have seen there is no debt or debt we can pay after sales of this asset, then we are in the solvent position. This is a declaration. So within 4 weeks of declaration, there shall be a special resolution of a company in a general meeting requiring the company to be liquidated voluntary, appointing insolvency professional. We have to appoint IP as a liquidator to act as a liquidator. The resolution of the member of the company in a general meeting requiring the company to be liquidated voluntary as a result of expiry period of its duration. This is the story. So provided that company own any debt to a person creditor representing 2/3 of value. आपके यहाँ कोई क्रेडिटर है तो उसके लिए आपको एक क्रेडिटर की मीटिंग कन्वे करनी पड़ेगी और 2/3 इन वैल्यू दे हैव टू गिव a consent kindly liquidate. So company shall notify the registrar of companies and board about the resolution under subsection 3 to liquidate within the 7 days of such resolution. SR पास कर दिया, अब within 7 days आपको ROC में और IBBI को intimate कर देना है, right? Subject to approval of the creditor, the voluntary proceeding in respect of company shall be deemed to be having commence. हम आपको यहाँ से जिस दिन आपने SR पास कर दिया लिक्विडेशन कमेंसमेंट डेट मान लेंगे, राइट? तो बाइंडिंग अप की प्रोसीडिंग आपकी स्टार्ट हो गई. सो द प्रोविजन ऑफ सेक्शन 35 to 53 ऑफ द चैप्टर नॉर्मल लिक्विडेशन इज एप्लीकेबल इन दिस केस ऑल्सो. So where the affair of the corporate company have been completely bound up and its asset completely liquidated, that liquidator shall make application to the executing authority for the dissolution of corporate affair. लिक्विडेटर अपॉइंट हो गया, क्लेम आ गए, क्लेम वेरीफाई हो गए, लिक्विडेटर एक एप्लीकेशन फाइल करेगा NCLT को कि काइंडली बाउंड अप. द एग्जीक्यूटिंग अथॉरिटी शैल ऑन एप्लीकेशन फाइल्ड बाय द लिक्विडेटर अंडर सबसेक्शन 7 पास एन ऑर्डर. NCLT का ऑर्डर आ गया कि भाई कंपनी को क्लोज कर दो. द ऑर्डर NCLT का ऑर्डर आपको विद इन 14 days फ्रॉम डेट ऑफ सच ऑर्डर फॉरवर्ड कर देना है अथॉरिटी को, INC 28 फाइल कर देना है. सो दिस इज अ स्टोरी ऑफ सेक्शन 59. आई जस्ट इन शॉर्ट वे इन लेमैन लैंग्वेज फॉर यू. नाउ आई कम टू ए order recently in a case of 21 Net India Private Limited. This order is for understanding of more detail for regulation. Slide. Yes. Board of Director of a corporate person by resolution 14th अगस्त 2020 बोर्ड की मीटिंग हुई अगस्त 20 में, डिसाइडेड टू लिक्विडेट द कंपनी. ये NCLT का ऑर्डर है जिसमें एक सिंपल प्रोसेस में आपको समझ में आएगा क्या रेगुलेशन है, क्या उसकी टाइमलाइंस होती हैं, कौन कौन से फॉर्म फाइल करने हैं, कैसे वॉलंटरी लिक्विडेशन होनी है. तो बोर्ड मीटिंग हुई है 14 अगस्त को. declaration of solvency in form number GNL2 with the registrar of companies on 23rd अगस्त आपको डिक्लेरेशन फाइल कर दी, आई एम अ सॉल्वेंट पर्सन. ऑन 17 अगस्त मेंबर पास अ एसआर इन अ एक्स्ट्रा ऑर्डिनरी जनरल मीटिंग. तो यहां पर एसआर पास हो गया, एलसीडी कमेंस हो गई आपकी. Liquidator, once the liquidator appointed within 7 days from the passing a resolution, we have to appoint a liquidator, and after the appointment of liquidator within 5 days make a public announcement in a newspaper. In this case there is one English newspaper and one Hindi newspaper, 2 newspaper is there. Form A has been published. Kindly submit your claims. I am appointed as liquidator in particular special resolution of the company ordinary. So liquidator notified the companies in MGT 14 and also to IBBI. So within 7 days from his appointment he has to notify to the ROC as well as IBBI. So another thing, liquidator commence the annual contributor meeting on, यहाँ पर AGM हो रही है. लिक्विडेटर बेसिकली कंपनी का नॉर्मली तरीके से अकाउंट्स भी मेंटेन करेगा, सब करेगा. बट CIRP में और लिक्विडेशन में क्या फर्क है? CIRP इज एप्लीकेबल इन केस देयर इज you are not able to pay your debt, but in liquidator you are a solvent company. So management continue to stay on their position. Management board of director रहेंगे. आप एनुअल जनरल मीटिंग कर रहे हैं, राइट? आपने जो लिक्विडेटमेंट कमेंसमेंट डेट से अब तक के एक्सपेंडिचर करे हैं वो भी आप उसमें उसका डिटेल शो कर रहे हैं. एनुअल स्टेटस रिपोर्ट भी सबमिट कर रहे हैं. लिक्विडेटर ऑल्सो गिव अ प्रीलिमिनरी रिपोर्ट विद इन 45 days. In the preliminary report they have to decide, is there some fraudulent transaction is happening in the company in order to defraud to the creditor. Then in the preliminary report within 45 days they have to give a everything picture of the company, what should be the process going forward. So subsequent payment to auditor, the liquidator close the account. उन्हें स्पेशल अकाउंट ओपन किया था वो भी क्लोज हो गया. फाइनल रिपोर्ट they have to file a final report. Usually final report is within 270 days from the commencement of liquidation commencement date. तो 270 दिन के अंदर आपकी फाइनल रिपोर्ट आ जानी चाहिए. इन केस देयर इज अ क्रेडिटर, इन केस देयर इज अ नो क्रेडिटर, आपका फाइनल रिपोर्ट विद इन 90 डेज आना चाहिए, राइट? Whole process of a liquidation should be completed within 12 months from the LCD to 12 months. If you are not completed your voluntary liquidation within 12 months, then you have to convey meeting, annual statement, status report every fortnightly. हर 15 दिन बाद आपको एक मीटिंग कन्वे करनी होगी. वहाँ आपको स्टेटस बनवाना होगा. लिक्विडेटर आप स्टेटस बताएंगे कि क्या कंपनी में स्टेटस चल रहा है, क्यों डिले हो रहा है भाई ये प्रोसेस. तो फाइनल रिपोर्ट आ गई. ऑन 30 मार्च complies section 59(6) read with regulation. Then the NCLT order हो गया. We are therefore of the considered view that the corporate person who is going to voluntarily liquidate, so the liquidator IP has voluntarily liquidated itself so as to act dissolve. Be hereby dissolve this corporate person, directing the liquidator to file this order with the ROC IBBI within 14 days. INC 28 आपको फाइल किया है within 14 days, right? This is the compliance of section 59 subsection 7, 8, 9. So this is the whole story of liquidation, voluntary liquidation. So kindly bear with us. I will discuss more on detail. So some is avoidance transaction. So liquidator, as I said, within 45 days will decide what is there any avoidance transaction, is there some preferential transaction is happen under the company, some undervalue transaction already happen in the company, some extrude, some fraudulent transaction. So this is called PUF transaction, PUEF. तो लिक्विडेटर की ड्यूटी बनती है कि वो PUF ट्रांजेक्शन को टेस्ट करे कि कंपनी में कुछ ऐसा तो नहीं हुआ है कि किसी को प्रेफरेंस दी गई हो पेमेंट करने के लिए और कोई आपकी असेट को अंडर वैल्यू पे सेल कर दी गई हो. तो यहां पर आपको लुक बैक पीरियड है 2 ईयर, राइट, 1 ईयर इन अदर. रिलेटेड पार्टी के केस में 2 ईयर तक आप जा सकते हैं बैक डेट में और अदर पार्टी के लिए 1 ईयर. नो लुक बैक पीरियड फॉर अ प्रिस्क्राइब फ्रॉडलेंट ट्रांजेक्शन. फ्रॉडलेंट ट्रांजेक्शन के लिए आप तो फॉरेंसिक ऑडिटर भी अपॉइंट करेंगे, वो कितना भी पीछे जा सकते हैं. So look back period of 2 years prior to the liquidation commencement date. Here it is mentioned ICD. It is in respect of CIRP. So in case of extraordinary transaction, related party or non-related party, transaction should not be in an ordinary course of business. So आपको कहीं पे भी ऐसा नहीं करने दिया जाएगा कि आपने पफे ट्रांजेक्शन करी हैं और लिक्विडेटर बिना पफे टेस्ट करे आपको लिक्विडेशन जाने देगा, क्योंकि डीप फ्रॉड करना आपकी एक वो नहीं होना चाहिए. अगर पफे ट्रांजेक्शन हुई है और लिक्विडेटर हैज प्रूव्ड देयर इज सम पफे ट्रांजेक्शन, देन ही कैन फाइल एन एप्लीकेशन बिफोर द NCLT, काइंडली सस्पेंड द प्रोसेस ऑफ लिक्विडेशन. So as I said, NOC, no dues certificate from the income tax department. IBBI has given a circular that there is no need for NOC. पहले इनकम टैक्स क्लियरेंस सर्टिफिकेट होता था, उसके बाद उन्होंने कहा कि NOC की भी रिक्वायरमेंट नहीं है, क्योंकि लिक्विडेटर ने पब्लिक अनाउंसमेंट किया है. विद इन 5 days ऑफ माई अपॉइंटमेंट आई हैव गिवन अ पब्लिक अनाउंसमेंट. किसी का भी कोई देनदारी है, अपना क्लेम सबमिट कर दो विद इन 30 days. उसमें 30 days के बाद मेरे पे 30 days का टाइम है कि मैं उन क्लेम को वेरीफाई करूं. टोटल 45 days में मेरे को उन स्टेक होल्डर का क्लेम का वेरिफिकेशन डिटेल बनानी है. अब इनकम टैक्स डिपार्टमेंट के बहुत सारे केसेस लग रहे हैं, GST की लाइबिलिटीज़ हैं, तो वो अपना क्लेम सबमिट करेंगे. नॉर्मली दे आर कंसिडर्ड एज अ ऑपरेशनल क्रेडिटर, वो भी अपना पब्लिक अनाउंसमेंट के बेसिस पे क्लेम सबमिट करेंगे. I have no reason to go for NOC. There is no requirement since this circular says. So IBI clarified that as per the provision of the code and regulation read with this section 178 of the Income Tax Act, and insolvency handling voluntary liquidation process is not required to seek any NOC from the Income Tax Department as a part of the compliance. So voluntary liquidation is a tax aspect also. For as I said, आपकी कैपिटल थी 1 करोड़, आपको मिल रहा है 1 करोड़ 50 लाख. तो जो 50 लाख एक्सेस मिल रहा है, इट विल बी ट्रीटेड एज डीम्ड डिविडेंड अंडर सेक्शन 222C ऑफ द इनकम टैक्स एक्ट 1961. सो ये डीम्ड डिविडेंड पे आपको टैक्स पे करना है. कंपनी के हैंड में कोई कैपिटल गेन नहीं होने वाला है, राइट. और शेयर होल्डर को जो कैपिटल गेन है वो भी एग्जेम्प्ट होने वाला है, ये मैं बता रहा हूँ आपको. सो डीम डिविडेंड ऑन द डिस्ट्रीब्यूशन ऑफ असेट ऑन अ लिक्विडेशन फॉर द कंपनी, डिस्ट्रीब्यूशन शैल बी ट्रीटेड एज अ डीम डिविडेंड अंडर सेक्शन 222C टू द एक्सटेंट एक्यूमुलेटेड प्रॉफिट. आपको 1 करोड़ का 1 करोड़ 50 लाख मिला, तो 50 लाख एक्सेस मिला, बट एक्यूमुलेटेड प्रॉफिट तो आ ही नहीं रहे हैं, तो दैट विल बी नॉट ट्रीटेड एज डीम डिविडेंड. तो इस पे डीम डिविडेंड पे टैक्स लगेगा 15% और ग्रॉस अमाउंट प्लस 12% सरचार्ज एंड 4% हायर है. ओ कैपिटल गेन सेक्शन 45 स्पेसिफिकली excluded taxation from the company angle. There is no capital gain in the hand of company, whereas the shareholder is continually liable for capital gain. Since suppose you got you have an investment in a company 1 crore, but you receive 1 crore 50 lakh, there is a accumulated profit is there. So 50 lakh will be treated as dividend. Company will pay 15% plus 12% plus 4% as DDT, but the 50 lakh is treated as dividend, not again taxable in the hand of shareholder. But company also give in lieu of your investment some asset, so that asset company will not charge any capital gain tax since fall under the section of 46. But since in against the right of shares you receive some property, then there is a capital gain in the hand of shareholder. This is a whole story of voluntary liquidation, how we will proceed and whether it is viable for us. We have to examine whether we are solvent and which option is better. So thank you.